Glad to have you back, everyone. You're still watching Newsnight. A federal high court in Abuja has dismissed a suit seeking to bar former President Goodluck Jonathan from contesting the 2027 presidential election and future polls. Justice Peter Alifu struck out the case filed by John Mary Jideobi, describing it as lacking merit and an abuse of court process. The judge held that the plaintiff failed to prove any personal interest affected by Jonathan's possible candidacy and therefore lacked the legal standing to institute the suit. Well, the court awarded 20 million naira costs in favor of Jonathan and 1 million naira in favor of the Attorney General of the Federation. No costs were awarded to INEC, which took no active part in the proceedings. Well, Justice Lifu aligned with earlier decisions in Andy Solomon versus Jonathan and Syracuse Njoku versus Jonathan, both of which dismissed similar claims challenging Jonathan's eligibility. The suit filed in October 2025 argued that Jonathan had exhausted the constitutional two-term limit after completing the late President Umar Musa Yar'Adua's tenure from 2010 to 2011 and serving a full term from 2011.
That this matter has come to an end, and we commend the court for the expeditious manner in which this case was handled. And if you listened to the judgment that was delivered, it was very succinct. And what is very important, and which everybody, particularly court users, must take heed of, is the need to reduce rushing to court for frivolous cases. I think that is the point. This is a matter that had been settled, and now you have someone filing the same suit when judgment already exists in respect of this. So this is a point that was well established. And secondly, the court also upheld the eligibility of Dr. Goodluck Ebele Jonathan as far as the constitutional requirements are concerned. So that is the very good takeaway from this matter.
Yeah, first I want to appreciate the court for the eloquent judgment, and for our president, President Goodluck Ebele Jonathan, and the PDP. The way is clear, and the PDP is ready for Jonathan, and by this judgment, Jonathan is ready to fly the flag of PDP. We shall all rally around him and ensure that, he becomes the next president in 2027. That's the work we have to do as a party.
To another court, a federal high court in Abuja has ordered the Independent National Electoral Commission (INEC) to amend its timetable for the 2027 general election to comply fully with the Electoral Act 2026. Justice James Omotosho, who delivered the judgment Tuesday, held that INEC cannot shorten mandatory timelines provided by law, although the timetable itself remains valid and legally issued. Well, the court specifically voided INEC's deadline of August 29 and September 16, 2026 for submission of nomination forms for presidential, National Assembly, governorship, and state assembly elections, describing them as inconsistent with the Electoral Act. The judge, however, affirmed that INEC retains the constitutional power to issue and adjust election timetables, including schedules for party primaries and submission of membership registers, as long as they comply with the Constitution and the Electoral Act. Well, the ruling comes days after another federal high court judge, Justice Muhammad Umar, nullified the 2027 election timetable in a separate suit filed by the Youth Party over alleged violations of the Electoral Act.
Right, let's examine today's judgment of the Federal High Court in Abuja, directing the Independent National Electoral Commission, INEC, to amend its 2027 election guidelines for alleged non-compliance with sections 29 sub 1 and 31 of the Electoral Act. We're joined now by Chinedu Obi, he's the Director General, IPAC, National Chairman, National Rescue Movement. Thank you so much for joining us on Newsnight.
Thank you, and thank you for having me.
I guess the court judgment, would give you the opportunity to actually rescue Nigeria since you're NRM. But first off, I mean, how much of a relief is this for political parties, especially your party, NRM?
Quite a very fantastic relief, even though it's coming late, because this judgment is coming almost at the point where the match had started. In fact, some of us had planned to conclude by May 30th. My party primary is fixed for 29th, and I'm sure a lot of other primaries, you read earlier of some of the ones that are happening with ADC, APC settled their own and so on. So, but we wish this had come much earlier, would have been more comfortable, because the timetable INEC issued to us was very tight,
Well, I mean, the court agrees on one hand that INEC has the power to set and adjust election timetable. And then on the other hand, it says it cannot abridge timelines set by law. Do you think that's a contradiction on its own? And what kind of uncertainty does this bring for you as a party?
The two judgments are more complementary than contradictory. They affirm the right of INEC to set timetable administratively, but agree that it has to be consistent with the Electoral Act. So both are quite complementary. I think INEC, whereas you have the powers to do whatever you need to do in terms of the timetable, we must not go against the provision of the Electoral Act.
Apparently, the court has played up the role of the Electoral Act as the final, more or less, arbiter, apart from, of course, the Constitution. Now, I mean, where does this leave your party? You say that you wish it had come earlier. To what extent, really, the INEC's, regulations constrict your party? And now that you have this, what seems to be room to maneuver, what will you do with it?
First, you realize that we had until May 3rd or so to submit our digital register. And that was just 3 months after the timelines were raised, asking us to have our members registered digitally. That was a huge task, knowing that it's difficult with the internet connection we have across board to have our members go online to register. My party in the last 8 years maintained a digital register. However, the new one introduced that you put fields like occupation, gender, name. Now, with this new introduction, you need to start all over again or do an update. For parties that haven't done that before, it was a huge tax. Now, if this judgment had come earlier, maybe INEC could have given us more time, maybe 4, 5, 6 months to enable us get prepared enough before we go into the activities. But with that short timeline, we needed to, like a fire brigade, which is why you can see almost all the parties are almost done with primaries. Whereas if this had gone to June, July, you will have time to have more Nigerians express interest, and then you can quietly go through the process and ensure that everything is done in line.
Yeah, but does it afford you the opportunity to take another look at some of the decisions that have been
Very
taken
well. Now,
process?
with their thinking initially, there wouldn't be room for substitution. But now it's very clear that we can do substitution. So those who lost the opportunity within this short time frame can come in for replacement, because, of course, the Electoral Act provides for us to do substitution of candidates.
Very well said. Chinedu Obi, Director General of IPAC and the National Chairman, National Rescue Movement, the NRM. Thank you so much for being here.
Thank you for having me.